The law has changed for one of Texas's most serious charges, intoxicated manslaughter. Why is this so urgent? Because in Texas, even with probation, you face 120 days in jail, no exceptions. And the prosecution doesn't even need to prove you intended to harm anyone. A fatal accident is enough. That single unintentional act can result in a sentence of up to 99 years, or even life in prison. We will break down why Texas law is uniquely severe, how prosecutors build their case, and how a defense can fight back. So, what is the standard penalty you face? Intoxicated manslaughter is a second-degree felony carrying 2 to 20 years in prison. But that's just the starting point. If the victim was a first responder, it becomes a first-degree felony. The punishment jumps to 5 to 99 years, or life. And the law has gotten tougher. Since September 1st, 2025, if more than one person dies in the incident, it's also a first-degree felony. What makes Texas different? It has a specific standalone intoxication manslaughter offense, unlike most other states. On top of that, prosecutors seek a deadly weapon finding for the vehicle, which severely restricts or eliminates parole. The penalties are severe, but the real danger is how prosecutors can secure a conviction. It's not what you would expect. If they don't have to prove you intended any harm, what exactly do they have to prove to put you away for life? The state's burden is shockingly simple. They only need to prove 3 things. 1, that you were operating a vehicle in a public place. 2, that you were legally intoxicated. And 3, that your intoxication was the direct cause of the death. No malice, just those 3 elements. And intoxication has a broad definition. It's not just a 0.08 BAC. It can mean losing normal faculties from any substance, including prescriptions. Why is the state so aggressive? Because Texas has one of the highest rates of alcohol-related traffic fatalities, creating pressure for harsh convictions. If the path to conviction seems so straightforward for the prosecution, where does the defense even begin? The answer is in challenging every single piece of their case. Remember our question. What does the state have to prove? A defense attacks each element, starting before the evidence is even collected. The traffic stop itself. Was the initial stop legal? Did the officer have probable cause? If your constitutional rights were violated, evidence can be thrown out of court. Next, field sobriety tests. These are notoriously subjective. Medical conditions, stress, or bad instructions can lead to a false failure. Even the hard science of a blood or breath test can be dismantled. Was the machine calibrated? Was the sample handled properly? What about rising BAC? This is where independent analysis becomes vital. A defense must hire its own toxicologists and accident reconstructionists to find the facts. But the most powerful defense strategy is often the most complex, challenging causation. This means arguing that your intoxication did not cause the fatality. What if the other driver ran a red light? What if there was a sudden mechanical failure? If another factor was the true cause, you are not guilty. Building this kind of defense requires deep expertise. But what happens if it fails? The consequences go far beyond just prison time. First, common plea options in other felony cases are off the table. Texas law forbids deferred adjudication, guaranteeing a permanent felony record. And a new law adds a staggering financial burden. If the victim had a child, a conviction requires you to pay restitution to that child until they turn 18. Let's connect the pieces. Remember the defense of challenging causation? Proving another factor caused the accident is nearly impossible without independent analysis. Think back to the prosecutor's advantage. No need to prove intent. Combined with first-degree felony penalties, a tragic mistake is punished like a premeditated murder. Given the complex evidence, the severe penalties, and the permanent conviction, one fact is clear. The success of a defense is often determined in the first 48 hours. So when we see the unique Texas laws, the numerous attack vectors for a defense, and the life-shattering consequences, what does it all mean? It means an intoxicated manslaughter charge is not a DWI. It is a complex felony prosecution operating under its own unique and severe set of rules. This is why dedicated statewide legal services are so significant. They're a direct response to the need for accessible expert defense. An accusation is not a conviction. As we've shown, there are numerous powerful avenues for a defense if you have the knowledge to use them. If you or someone you care about is facing this charge, Your entire future is on the line. The most important decision is to contact a specialized attorney immediately.